And then we have two discussants waiting. Dr. Omri is an experienced expert in international law and legal proceedings who works as a partner and chair of the Public International Law Practice Group at Horowitz & Co. in Tel Aviv, one of the largest law firms in Israel. And we have Dr. Mohd Norhisyam bin Mohd Yusof. Dr. Norhisyam is a high-level foreign service official of the Malaysian government and currently serves as Deputy Director General of the Maritime Affairs Department at the Ministry of Foreign Affairs. We particularly appreciate his presence today because he represents an important perspective from Southeast Asia, where there are a lot of developments going on in terms of the law of the sea. Now I'm going to ask our two discussants to share their views on the topics covered by the speakers. So Omri, you may go first.
Thank you, Dr. Hank, for your kind introduction, and many thanks also to the Korean Ministry of Foreign Affairs, the International Tribunal for the Law of the Sea, the Korean Society of International Law, and all those who have put together what has been a very enjoyable and very interesting conference yet again. It is both an honor and a pleasure to be here. It's also a pleasure to be commenting on two very insightful presentations, and in particular to share with them the sentiment the dispute settlement under the Convention has, over the past 30 years, been a success. It is moreover interesting to note that while Professor FORTEAU sees and demonstrates similarity and consistency, Professor LANDO observes and points to a lack of a unified approach. Against this background, I wish to offer 6 brief observations additional to those made by our impressive speakers. Turning first to the question of choice of means, it is worth noting what a long way the term forum shopping has come. It was originally a pejorative one, referring to an applicant who bypasses a natural forum in favor of another forum where greater benefit may be available. As such, it was often frowned upon as illegitimate manipulation and unprincipled gamesmanship. But forum shopping no longer has a bad name. We saw that today. This may be owing to the fact that there is, after all, nothing fundamentally wrong with the idea that an applicant should be able to choose any available forum in which it thinks its case can most favorably be heard. The lack of indignation at forum shopping may also be due to the fact that, as Andreas Lowenfeld put it a long time ago, forum shopping, and I quote, which used to be a favorite indoor sports of international lawyers, has developed into a fine art. Indeed, counsel should be expected to inform their state clients of all the options available to them, including the court or tribunal that may recognize their rights best. Fears of fragmentation of international law no longer have a hold on states in this regard, if they ever did. And of course, forum choice should not be abusive. A second and related point, and one that Professor LANDO alluded to, is that the possibility of forum shopping may lead to benefits not only for the applicant, but also more broadly. A healthy measure of competition among the different available dispute settlement fora can indeed serve to encourage both quality and efficiency, including in terms of procedural improvements. In this way, forum choice can benefit international law and the international legal system as a whole. This may serve to explain, at least in part, precisely why UNCLOS itself allows for choice of procedures, while at the same time, of course, restricting and delineating it. Third, it is not only that similarities largely prevail over differences between judicial settlement and arbitration. The expanding practice of these dispute settlement means has also influenced the structure and process of other dispute settlement means, including under the Convention. I'm thinking more specifically of conciliation, which in certain respects has come to resemble a judicial process. In the Timor Sea compulsory conciliation, the parties early on retained the service of seasoned counsel. Members of the Conciliation Commission were themselves all international lawyers, and they engaged the Secretariat of the Permanent Court of Arbitration as a registry. As we know, Australia soon applied to bifurcate the proceedings, setting out various challenges to the competence of the Commission. and following written submissions on this issue from the parties, the Commission convened a hearing on the question of competence at the Peace Palace in The Hague. Legal arguments concerning the proper interpretation of the Convention were central to the Commission's decision on competence. They were also an important factor in the later phase of maritime boundary delimitation. This is not at all to say, however, that the success of the process did not ultimately owe to its more informal, non-adversarial, and flexible nature. While it is certainly true that arbitration and judicial settlements have become more similar in various ways, my view is that the point should not be stressed too far. In a given case, differences can still be so significant so as to constitute a decisive incentive for forum shopping in practice, and that must be borne in mind. For instance, with arbitration, the tribunal under the rules adopted for the case may often decide not to allow preliminary objections to suspend the consideration of the merits, whereas the ICLOS and the ICJ, the rules provide that there shall be a separate stage. That can be very important in practice. In the Chagos Marine Protected Area case, for example, the decision of the arbitral tribunal not to have a separate preliminary stage, taken after a hearing held in Dubai, meant that the United Kingdom had to argue its full sovereignty claim, even though it considered that the matter fell outside the competence of the tribunal, as indeed it did. The amount of work and preparation that may be required in such a case may be considerably larger than that in which proceedings are bifurcated. In the Ghana Cote d'Ivoire case, as another example, the parties agreed to transfer the arbitral proceedings to ICLOS on the condition that if any objection to jurisdiction or admissibility were to be raised before the special chamber, it shall be dealt with together with the merits. They therefore agreed not to take advantage of the automatic suspension of the merits phase provided for in the rules of the tribunal. The question of enforcement may also be a relevant one, as some states may find appealing the existence of Article 94 of the United Nations Charter, even if it has never to date been used effectively. As emerged perhaps from one of yesterday's panel, and even though case fertilization is generally observed, where there is a favorable precedent in one forum, that too may be appealing in the sense that the court or tribunal in question is more likely to follow its own precedents than another court or tribunal. As another difference, where a state may be interested in interventions by others, arbitration may complicate matters, as the question of intervention in arbitration, I think, is not so straightforward. Conversely, if a party wishes to avoid interventions, which seem to be rather common these days, arbitration may be attractive. I would further suggest that a hearing may be very different in arbitration, in the sense that arbitrators may sometimes, but by no means always, choose to ask many questions and expect immediate answers. They may engage in conversation with counsel, as often happens in common law jurisdictions. This may have a very considerable impact on how arguments are put forward and also on how arguments are received. To this, it may be added that other, perhaps wider considerations may sometimes be at play in guiding the choice of forum. Empirical research conducted in the United States some years ago, for instance, suggested that there is a correlation between the type of domestic legal system that a state employs, common or civil law, and its chosen forum under Part 15 of the Convention. So the differences that remain between the different forms of judicial settlement are even more visible in relation to advisory opinions, and this is my fifth point. As Professor FORTEAU suggests, advisory proceedings nowadays, and I quote, have to be added to the panoply of available dispute settlement means and to be integrated into any forum shopping strategy. Recourse to this procedure, which has been referred to as contentious proceedings in disguise or as soft litigation, has become increasingly strategic and increasingly politicized, creating a visible crack in the edifice of the principle of consent to jurisdiction. Appetite for advisory proceedings has no doubt grown following the political outcome of the Chagos advisory opinion and also the finding by the Special Chamber of ICLOS in the Mauritius-Maldives case that even if advisory opinions are not binding, the judicial determinations made in them do have legal effect. In terms of process, advisory proceedings may offer those considering this option several significant advantages. For a start, they may alter any power imbalances between the parties to the underlying dispute. Being open to all states, or all states' parties, as the case may be, and sometimes to additional actors other than states, they afford one side or the other the ability to harness and put on display before the court or tribunal a wide measure of international legal support. This may have critical significance. Financial cost may well be lower in the case of advisory proceedings than that of contentious proceedings, and important challenges like the burden of proving the facts can be avoided. It will therefore be for the court or tribunal in question hopefully to keep in mind that the advisory process does not afford the parties, so to speak, the same procedural protection of contentious cases, both in terms of establishing the facts and sometimes even for ironing out the legal issues that are in dispute. A final remark is that it is well to remember that in appreciating the dispute settlement system under the Convention, there is much more than meets the eye. It is not only that non-adjudicative means also play a role in the settlement of disputes, but also that even when international courts and tribunals are not utilized, their very existence may well have contributed to encouraging states to comply with the law and to negotiate solutions to their disputes. The value of the dispute settlement regime under UNCLOS is therefore not to be judged solely by the cases. There is, of course, much more to say on what we've heard today, but I will stop here. Thank you for your attention.
Thank you, Dr. Sander. Thank you very much for your interesting observations that could enrich our discussion today. Now I'm going to ask Dr. Norhisyam to take the floor. Thank you.
Thank you, Dr. Huang Jun-shik, for the brief introduction. Being the last person to speak at the in the last session is a mounting distress to some, but I'll try my best. At the outset, allow me to express my gratitude and appreciation to the Ministry of Foreign Affairs of the Republic of Korea, the International Tribunal of Law of the Sea, ICLOS, and the Korean Society of International Law for organizing this important conference in this beautiful and vibrant city of Seoul. My special thanks to the government and Ministry of Foreign Affairs of the Republic of Korea for the excellent hospitality that is beyond doubt above first class. And let me also state the obvious caveat that irrespective of nature of my position with the Ministry of Foreign Affairs or Government of Malaysia, my comment here do not represent the official position or stance of the Government of Malaysia or the Ministry of Foreign Affairs of Malaysia. I would like to offer some observations on the presentations by our two esteemed speakers, Professor Mathias and Dr. Massimo LANDO, on the settlements of disputes under UNCLOS. First, on Professor FORTEAU's excellent presentation. The dispute settlement mechanism under UNCLOS has been hailed as an ambitious and comprehensive framework for resolving international maritime disputes. Typically, diplomatic means, including but not limited to talks and negotiation, have been the most efficient way to resolve the conflict. Part 15, Section 1 of UNCLOS promotes dispute resolution through political channels before a judicial settlement through the obligation to proceed expeditiously to an exchange of views when differences over interpretation and application of the convention emerge. States also retain rights to resolve conflicts through alternative agreements, be that at bilateral, regional, or general agreements. States negotiating UNCLOS recognize that the mechanism for dispute settlements must be part of the package deal, the result of which understanding paved the way for the agreement under UNCLOS Part 15, a complex dispute settlement system that entails both traditional consent-based process as well as mandatory procedures. In both respects, flexibility for states parties is a key feature. Section 1 anticipates that states will Section 1 of Part 15 anticipates that states will pursue a range of dispute settlement options both within and outside the UNCLOS framework, reflecting that states have been accustomed to settling disputes in a variety of ways as those disputes arose and as demanded by the situation, not through predetermined means. The dispute settlement mechanism under UNCLOS provides a structured process for resolving conflicts related to the interpretation and application of the Convention. Each of these forums has its respective procedures and jurisdictional boundaries, leading to a confusion about which forum is appropriate for different types of disputes. In theory, this flexibility can offer a tailored approach to dispute resolution. However, in practice, the multiplicity of options can make it difficult for states to navigate the system effectively. Parties may be uncertain about which body they should approach, leading to delays and procedural inefficiencies. For example, states may engage in lengthy negotiations over a choice, even a choice of forum, which itself can be a source of further diplomatic friction. The existence of multiple forums with varying rules, processes, and jurisdictional reach allows the possibility of forum shopping. States can potentially choose the venue that they believe will be the most favorable to their position, a strategy that undermines the credibility and fairness of the dispute resolution process. For instance, a state might choose a particular body based on the perceived leanings of its judges or arbitrators, rather than seeking a neutral and equitable resolution to a dispute. This can lead to inconsistent outcomes, as the same legal question could be decided differently depending on the chosen forum. This undermines the uniformity and coherence of the international maritime law, which is supposed to be governed by UNCLOS. This practice can lead to duplicate proceedings. Parties to dispute may invoke more than one dispute resolution mechanism simultaneously, seeking to resolve the same issue in different fora. Further, in some cases, disputes might involve not only UNCLOS but also international treaties or bilateral agreements, leading to the possibility of multiple proceedings under different legal regimes. Different fora may issue conflicting rulings on the same issue, leading to uncertainty and inconsistency in the interpretation of international law, particularly UNCLOS. Parties and international institutions may invest significant time, effort, and financial resources in multiple proceedings that ultimately duplicate each other, causing inefficiencies. This will be the disadvantages to developing states as opposed to the wealthier ones. The simultaneous pursuit of parallel proceedings can exacerbate tensions between disputing parties, especially if the result diverges or one party is dissatisfied with the resolution reached in one forum while the other continues in a different forum. Multiple proceedings can delay the final resolution of a dispute, as parties may strategically prolong one case while waiting for the outcome of another, or the outcomes may be inconsistent, requiring further negotiation or reconsideration. Some or more specialized mechanisms can be costly to access, requiring significant financial and legal resources. Developing countries or smaller states might find it difficult to afford the expenses associated with pursuing a dispute settlement through these channels. This can result in an imbalance where wealthier states with better access to legal expertise and resources are better positioned to protect their interests or their interests under UNCLOS. The choice of means in UNCLOS dispute settlement mechanism provides a comprehensive framework for resolving maritime disputes. However, for the system to remain effective, it must balance state sovereignty with the principles of international law ensuring that all parties adhere to and respect the processes established. While the current system allows for flexibility, challenges remain in terms of ensuring consistent compliances and addressing political consideration that may influence a state's choice of dispute resolution method. Now let me turn to the outstanding presentation by Dr. Lando. Certainly the tendency of UNCLOS tribunals to expand their jurisdictional coverage has been a subject of ongoing discussion in international maritime law. This trend can be understood in several ways, reflecting both legal developments and evolving interpretation of the Convention's provisions. UNCLOS provides a complex framework for regulating the rights and responsibilities of states concerning the use of oceans. UNCLOS tribunals, particularly ICLOS and PCA, have sometimes interpreted the jurisdiction in ways that extend beyond what was initially envisaged. This has been driven by the need to address emerging issues such as environmental concerns, marine resources management, and marine security. Case to highlight such as the South China Sea arbitration in 2016. The tribunals have shown a willingness to assert jurisdiction over dispute concerning maritime boundaries and the interpretation of various provisions of the Convention, even when another state may not have agreed to arbitration. Initially, UNCLOS tribunals dealt with disputes over traditional maritime issues such as territorial seas, economic zones, and continental shelf. However, recent cases have seen the tribunals expanding into new areas of maritime law, such as the protection of maritime environment, sustainable fishery management, and navigational freedoms. These new areas have often required tribunals to interpret UNCLOS provisions in ways that broaden their jurisdictional scope. This can be seen through the recently climate change advisory opinion by ICLOS. The compulsory dispute settlement procedure under Part 15 gives tribunals significant authority to hear disputes between parties. While states can opt out of compulsory jurisdiction in certain matters, such as military and security-related issues, the overall structure encourages tribunals to assert jurisdiction where applicable. The expansion of case laws resulting from more states utilizing this dispute resolution process can contribute to the extension of the tribunal's reach. In a broader context, international law itself has been evolving to address issues like climate change, biodiversity, protection, and global shipping. UNCLOS tribunals have interpreted their jurisdiction as extending to these emerging issues, and cases reflect a trend where tribunals assert more jurisdiction to adapt the Convention to modern maritime challenges. Nevertheless, concern regarding judicial overreach highlight the delicate balance between enforcing international law and respecting state sovereignty. While the international tribunals provide an essential functions in interpreting and applying UNCLOS, it is important for us to address these concerns in a manner that reinforces the legitimacy and primacy of the states. The future of UNCLOS dispute settlement will depend on continued dialogue between the international courts, states, and other stakeholders to maintain a fair, balanced, and effective approach to ocean governance. Thank you.
Thank you very much for your very interesting observations. Well, it seems that we have enough time, and before we open the floor, I think I might be wrong, but it is interesting to see that we have two academics presenting challenging views that challenge the kind of the conventional wisdom, while we have a government official and a lawyer who acts as clients or representing clients. I think there is a very interesting contrast between these two meaningful and insightful presentations. So we have enough time for the audience participation. So yes.
Well, thank you very much, and thank you to the panelists for their interesting comments. A couple of comments and a question. Firstly, as Professor FORTEAU no doubt is well aware, the French delegation, when Part 15 was being developed, took a very strong line against a permanent court and in favor of arbitration. The leader of the French delegation said, préconstitué, c'est mal constitué. If it's predetermined, the composition, it's a bad composition. I wondered if Monsieur FORTEAU agrees with that. A second point is that an obvious convergence has been the decision of the ICJ that its provisional measures are legally binding, which it's generally thought it took because ICLOS had legally binding provisional measures and decisions under tribunals under Part 15, it's expressly legally binding, so the court probably felt it had to catch up in that regard. That seems to be a very important convergence. Then the question is really this. It was the US delegation that pressed so hard for compulsory dispute settlement, and very successfully. They persuaded the Soviet Union and China and others to go along with this, which was remarkable. It probably wouldn't have happened at any other time, but they were successful. Now that so much of the convention has become customary international law, one of the big differences between being a party and not being a party is that you are bound by compulsory dispute settlement in many respects if you're a party. So the question is, do you think that this remarkable, and lawyers would largely say positive, compulsory dispute settlement under Part 15 may have a negative effect in the sense that it could even persuade states to denounce the convention and cease to be a party if they're very dissatisfied with a particular case, and it could persuade, it could discourage states that are not yet parties from becoming parties. I'm thinking of the United States, for example. It's not an issue they've raised publicly very much, but I wonder when they get to think of it, they might be very concerned about the compulsory dispute settlement, which they themselves said was essential for the convention. Thank you.
Could you give the mic to Mr. President? Yeah.
Thank you very much for really interesting presentations. You complement and to some extent contradict each other. It's a very interesting combination. I want to make just three points. First, I wanted to agree with what Dr. Sender said about the healthy competition. If one were to imagine that we had one court with monopoly over all law of the sea issues, I don't think that would be particularly healthy. So I think it is rather more healthy to have this competition, and I think it gives an extra incentive to the courts and tribunals to really ensure the quality of their decisions, be them judgments or advisory opinions. And related to that is the fact that although there is a lot of convergence, I think, between those, in the decisions between those ICLOS, ICJ, and arbitral tribunals, there is still, and I think Professor FORTEAU hinted at that by mentioning the outer continental shelf issues. And examples of that would be, for example, Somalia, Kenya on the one hand, and Mauritius, Maldives on the other. Obviously, the situation in those cases was probably quite different, the scientific situation, but the approach of the ICJ and of ICLOS was quite different, and I think this can best be appreciated by looking at the dissenting opinion of Judge Robinson and even the separate opinion of the President Donoghue. I think they were very much in line with the thinking of ICLOS, both of them. So it's a very interesting comparison between these two judgments. And of course, although Sir Michael did argue differently yesterday, I think you could make the case also that there is quite a significant difference between the Nicaragua-Colombia case on the one hand and the Bay of Bengal cases by ICLOS and Annex 7 arbitration on the other. So there are some differences, and I think, I'm sure that the Council are looking and parties are looking very carefully at the jurisprudence when deciding where to go with their cases. So I think that is all just very healthy. And just a final point is that I hinted at this in my keynote yesterday. there is this trend that is quite relevant to what we are discussing today of transferring disputes from arbitral tribunals to ICLOS. And this happens kind of naturally because in almost no case will the parties to Annex 7 arbitration agree on the 3 remaining arbitrators. And therefore it is the president of ICLOS that nominates those 3 in consultation with the parties. And during those consultations, it has increasingly happened that the case is transferred to ICLOS. And if I take just the examples of the maritime delimitation cases, the three ICLOS cases, they have all been transferred in this manner, in a different way though, because the Bangladesh-Myanmar case went to the whole tribunal, to the plenary tribunal. So Bangladesh-Myanmar was decided by all of the judges. Ghana-Cote d'Ivoire was decided by 5 judges, so you could say that the composition was probably the same that would have been if it had been continued with an Annex 7 arbitration. And then you have the middle ground, which is Mauritius, Maldives, where the conclusion was a special chamber of 9 judges. I think one party was rather in favor of having a full tribunal, and the other party inclined to have a special chamber of 5, and the compromise became to have a special chamber of 9. The point is that there is a lot of flexibility involved in these transfers, because you can have the same size of body as arbitral tribunal 5, you can have the full tribunal or some middle ground. So I think that is also just very good to have flexibility in the system to be able to accommodate the desire of the parties. Thank you very much.
Thank you. Just because we have been, we have received questions from the 2 great experts, you don't have to be overwhelmed, okay? So we are welcome, we welcome any questions from the audience. I think we give a little more time for 1 or 2 questions. Okay, another great expert, okay.
Thank you very much. I agree on the tendency to convergence between the various settlement of disputes means and in particular the adjudicatory ones. I don't see, but maybe I'm wrong, any convergence in state practice in the sense that the convergence is possible when states have a priori accepted all means under the declaration they may make. So I see that the tendency by state is still to prefer an ex post consent. So they don't choose, the majority of them, any adjudicatory means. So this will lead to a compulsory jurisdiction of Annex 7 tribunal. Then after the dispute, they, as the president have mentioned before, they decide to move the case from the compulsory jurisdiction to the tribunal, or maybe in the future in other, in following other mechanism, even vice versa. But I don't see that this convergence is perceived so that the consent is given a priori, opening the door to the full range of adjudicatory means, while on the contrary is an ex post facto choice. Thank you.
Okay, if there is anyone who is determined to pose one final question. Okay, there's a lady there.
Thank you very much for giving me the opportunity to raise a question, and thank you very much for the very interesting presentation and discussion. My question is about the, the future of the UNCLOS and the dispute settlement procedures. Like, since our conference's subtitle is about then, now, and the future of the UNCLOS, future of UNCLOS. When I think about the future, like the scientific and technological advancement came into my mind. So yesterday we talked about the offshore wind farm or submarine cables, which are the result of the scientific advancement, and how they affect the implementation and application of UNCLOS. So my question is about, is there any kind of opportunity or possibility that those kind of scientific and technological advancement affect the implication and application of the Part 15 of UNCLOS? Thank you.
Thank you. She forgot to identify herself, but I think she's a colleague from the Ministry of Foreign Affairs. Thank you. Okay, Mr. Professor FORTEAU, you can go first.
Thank you very much for all these questions. I will try to, in fact, reply to all of them under one single umbrella, which is that, of course, in 1982, the French were wrong, as ever. The French were wrong because you cannot think about Part 15 in a static way. It is something which evolves over time. So maybe it was true in 1992 that there was a strong distrust regarding permanent courts or predetermined permanent courts. But in fact, I've seen over time that this distrust disappeared. So I think it shows that we have to take a look to the dynamic of the things and not to have a static approach of Part 15. In the same direction, competition is good. I totally agree. And competition is a strong incentive to have more convergence between court and tribunals. And the examples of binding provisional measures is a very good example. But we have other examples. For instance, the time limit for the submissions of preliminary objections was amended before the ICJ to follow the practice of the ICLOS, and you have the examples in the other way around. So competition is a good incentive to have more convergence between courts and tribunal. I think that we should not consider that each court have a static case law. I think that there is more difference. If you take the example of Kenya-Somalia, I think that there is more difference between the general practice of the court and the Kenya-Somalia decision than before the general practice of the court and the ICLOS. The adjustment of the equidistance line in Kenya-Somalia was very exceptional as compared to what the ICJ used to do in the past. So it's very difficult to say that it's the ICJ versus the ICLOS. It depends on the cases, and we cannot expect what could be the evolution for each court of its case law and jurisprudence. I think that the same is true for the state practice. The fact that there is a kind of wait-and-see approach of states with regard to dispute settlement shows that there is no strong differences between each court and tribunals. If there were strong differences, states will make a choice right at the beginning, but they don't do it because it will depend on the situation, which court or tribunal could be seen as being a better one for this specific dispute. So I think all these elements go in the same direction, that the dynamic is going toward more convergence, not uniformity, but more convergence. Lastly, on the last question, this is the same idea. You have at Article 235 of the Convention, paragraph 3, which is a provision which is in part 12 on the environment, protection of the marine environment. This provision said that state parties should cooperate to further develop international law in relation to responsibility and in relation to settlement of disputes. So there is room for evolution, and this evolution was contemplated in Article 235, paragraph 3 of the Convention, and I think this provision could be used also to address some of the problems that were addressed by Dr. Yusof later during this panel. Thank you.
Thank you. Professor LANDO?
Thank you very much. I won't say much. I will make 2 points, and may I ask a question? Very good. So the 2 points. The first one concerns the state practice, the idea that states give consent ex post instead of giving consent ex ante. That doesn't seem like anything strange to me. I think that if I were a state, that's exactly what I would like to do. I would like to maintain as much control as I can, especially at this particular time. As I was saying during the presentation, we are at a time when it doesn't seem particularly frequent for states to give ex-ante consent. There is a real backlash against binding third-party settlement, and perhaps things will change in the future, but Sir Michael aptly said, some things, they just happen sometimes at some point in time, and they never again repeat themselves. Who knows? It remains to be seen, I suppose, but it doesn't surprise me that that's the case. Concerning the future of UNCLOS dispute settlement procedures in the context of scientific advancement, well, it is possible for UNCLOS courts and tribunals to do something about it already. I'm going by memory now, Article 289 of the Convention concerning the co-optation of experts into ICLOS, for example, for the determination of certain particular disputes, similar to what assessors would be in the ICJ. There is a degree to which these figures could actually be used, but they haven't. It is beyond me why necessarily they haven't in certain particular disputes that do raise complex scientific questions, and I'm thinking, first of all, of questions concerning the delimitation of the continental shelf beyond 200 nautical miles. I mean, we have a CLCS, use it. At least that's how I feel about it. But again, I'm an academic, not a practitioner. And the question that I wanted to ask, I would like to ask it of Dr. Sender. He referred to a study that was done in the US, apparently, concerning the preference that certain common law jurisdictions seem to have for certain particular means of dispute settlement in the context of Part 15 of UNCLOS. And I'm assuming that these jurisdictions, they prefer arbitral tribunals over standing tribunals, given the interaction with the parties, and correct me if I'm wrong, of course. But I wonder, what happens if there is an arbitral tribunal that is entirely staffed with civil law arbitrators? Does that make a difference? Or this is purely hypothetical, I realize this, but it just came to me as a question to ask, I suppose. Thank you very much.
Okay, Omri, you may want to answer the question. Okay,
Thank you. Well, hopefully in arbitration you get to choose the arbitrators. So if you resent the civil law tradition, or one way or another, you can just not choose civil law lawyers. I will happily address this last question that was brilliant by sharing an anecdote that came from New York during the course of the negotiation of a convention recently, where somebody said, and it just shows how these advancement in science and technology can also end up in courts and in the decision process making of arbitrators and judges. And apparently a certain state was very adamant that it would not accept a certain word that was used in the draft that it did not like, and suggested another term, where other states were telling it actually means the same thing. The words we are using means the same thing as the word you're using, but we would like to do it this way and use this word. And apparently the debate went on for a few days until somebody had the bright idea of asking GPT. And when they asked ChatGPT, do these two words mean the same thing? The response was, yes, they do. And that state caved in, and that word made its way into the text. Now, if one day the meaning of that provision comes before a tribunal that has to look at the drafting history, for example, how would that be used or seen? That remains to be seen, but it does show us that these developments have an impact in practice and may still come and surprise us in the future.
Thank you. Professor FORTEAU, are you sure you don't have any question to the discussant? Okay, thank you very much. I should say this was a truly meaningful opportunity to reflect on the past, present, and future of the dispute settlement system under UNCLOS and dive deeper into multi-layered and nuanced implications. So I'd like to thank our speakers and discussants for their excellent presentation, intervention, and insightful discussion. And so this concludes session 5. But before adjourning our conference until next year, let me take the advantage of moderating the final session of this conference and make short closing remarks on behalf of the Korean government as one of the co-organizers of this conference. As expected, the level of expertise and insight we have witnessed during the conference has been truly inspiring. And I'm certain that we have made a lasting mark in the international legal discourse on critical issues concerning the law of the sea for the coming years. And the topics of our sessions are as much relevant today as they were in 1982 or 1994. And some of them became even more relevant and significant now. Despite the different perspectives and approaches of each speaker, there appears to be a consensus that we are on the right track in our efforts to enhance and strengthen this 30-year-old legal regime rather than seeking to move away from it. This reaffirms the significance and potential of UNCLOS as living instrument. I would not go far as to call it the Constitution because of some objections. The convention holds special importance for Korea due to the highly complex maritime relationship we have with our neighboring powers, which directly affect our survival and prosperity. The legal stability and strategic leverages offered by this legal framework are so invaluable, and it's no surprise that we stand as a strong advocate of UNCLOS, just like many other state parties. And it is in this context that we are engaging with our opposite coastal states, that is Japan and China, within the framework of Articles 74 and 83 of the Convention. Next year, we'll have the 10th International Conference on the Law of the Sea. And I hope this conference continues to promote academic dialogue and exchange of ideas among experts, governments, and all the relevant stakeholders from around the globe. And I would like to express our gratitude to ICLOS and the Korean Society of International Law for making that happen year after year. Once again, we thank all the speakers, discussants, and audience members for your outstanding presentation, discussion, and active participation and engagement. Safe travels, and we hope to welcome you back to Korea for future gatherings. Thank you.
Thank you once again, Director General Hwang, and all the speakers for the wonderful speeches and discussions. Ladies and gentlemen, please give a big round of applause for Director General Hwang, and also all the speakers on the stage.